Hi, good afternoon, everyone. Thank you for coming out to most of the summer associates. I haven't met you yet because I just was on vacation for 10 days. I'm Lucy Malcolm, and this is Rachel Cressa, who some of you may have met. So Rachel and I organized the Summer VAWA program. None of us are on teams with you, but we're sort of here to help as needed and set things up. So feel free to ask us if you have any questions. And the first kind of event is that Esther Lim from Her Justice is here to give you guys a training, tell you how to do these things. Esther is fantastic. Any questions you have, she can answer. And I think that's it. I will turn it over to Esther. We have seen this training before, so we're not going to stay, but again, feel free to email if anything comes up, and good luck with the training.
Thank you.
Thanks, Esther.
Thank you. Thanks, Esther.
Hi. Hi, guys.
Hey.
Hi, my name is Esther. I'm a senior staff attorney at Her Justice. This is a kind of a long training. It's a lot of information. So if you need caffeine, go get some. You can stand up and get some during the training as well, not a problem. But we do have a break. It's a 10-minute break. So in between, if you want to get food, if you want to go get something to drink, please feel free to do so. And I'm kind of at a loss of how this works. Just, yeah, can you play it? We're going to show a short video about Her Justice real quick, and then we'll get into the training.
As a lawyer and a New Yorker, I am proud to live in a city that takes care of its own. At Her Justice, we provide legal services to low-income women in crisis in the areas of family, matrimonial, and immigration law. Last year, Her Justice provided legal services to over 3,000 women, and there are over 4,000 children. Our clients are incredibly strong, and many of them have survived great hardship. What they don't have is access. Her Justice makes sure that our clients receive that access by connecting them with private attorneys from around the city, so that our clients have access to the legal tools that give them safety, security, and self-sufficiency.
We used to fight a lot, and he still gives me this tough morning that I see more than one occasion I tried to live my life, because there was not a way out.
He wanted my pension, 401k, medical benefits. He wanted my furniture at one time. It seemed like he was winning all along, you know?
My client was arrested because her abuser had actually called the New York Police Department and alleged that her client was harassing him.
My marriage was based on deceit, and it escalated from verbal abuse to physical. Quería romper un ciclo que no era beneficioso para mí ni para mis hijos. Tú vas a salir de casa y mi hijo se va a quedar en casa.
Court itself, it is not being operated in a way that is helpful to the very people that it was set up to serve.
While our clients may have compelling stories, it doesn't necessarily mean that their entire stories can be heard without lawyers stepping in.
When people go to courts and they don't have a lawyer, they come up short, even when the law has been designed to protect them. When we have 12 attorneys on staff who can then leverage the legal support from the private bar, we are able to represent and help over 7,000 people every year.
Because of the law firms that donate their services to us, and because of our people living on walls that are able to train them, help represent our clients, that is how we're able to best serve the community.
The work of Her Justice is vital to women who are not in a very empowered status. It can be very difficult for them to assert the rights that they do have. Her Justice empowers these women to understand that they do have rights. Many of our clients are completely in the dark about the financial circumstances of their marriage. We know that our pro bono attorneys can make the biggest difference in the lives of those clients by partnering often with financial accounting firms to investigate the income of the spouse and get the client a fair financial reward.
We'll look for hidden facts such as the defendant's hiding income, hiding employment, hiding assets, and we use our investigative experience to get the information that's most helpful to Her Justice and the pro bono attorney.
Providing pro bono services means that I get to see those results on someone's face when they get an order of support or an order of protection to get them the financial means that they need to help raise their child or to get them safety away from someone who's putting them in danger.
We know we have these incredible mentors, brilliant, talented, resourceful, responsive attorneys who sort of have our back in every matter.
In my
experience working with the attorneys at Her Justice, I have been so impressed by their dedication and commitment and the quality of service that they provided to their clients. I actually grew up in foster care in New York, and as a child, I never had access to the quality of professional and legal services that Her Justice provides.
I think her life is unactively different because she came in contact with Her Justice. She might have been deported by now. Instead, she has status and she's living with her daughter here.
If I didn't have Her Justice there to help me with the case, I would still be married to the man who raped me and tortured me.
The fact that Alice's husband was sentenced to 40 years in prison really speaks to the brutality of what Alice endured. Without Her Justice, Alice would have had to face her accuser in trial alone.
Judge ordered that he does not get any part of my retirement or 401k or any medical or furniture or whatever he wanted. He's getting nothing. I was unable to even. I have a work permit now. The fact that I had a social security number and I was able to have a bank account to deposit my check. It's like I'm normal.
I don't think I'll be who I am today. Confident, relaxed, secure, happy. Without Her Justice, my life would be totally different.
As a lifelong New Yorker, I'm proud to be part of the Her Justice community, where we shift the power to the low-income women who call us every day, who are seeking to build safer and more secure lives for themselves and their children.
Ha sido difícil los cambios, pero lo importante que tenemos es la tranquilidad y estamos saliendo adelante gracias a esta agencia, Her Justice. I want to thank Her Justice for her amazing team. It inspires you to put your best foot forward. I want to thank Her Justice for giving me my life.
Give her opportunity, dignity,
Give her courage.
security, access.
Compassion.
Un mejor futuro en every day.
Give her justice.
So that is our short video. A little bit about who we are, what we do. We, as you saw in the video, we partner with large law firms to do with the pro bono work. We are pro bono first model, where we train law firm associates and folks to take on these cases pro bono for us. Okay, so today we will be talking about the VAWA self-petition immigration cases and hardship waiver immigration cases. If you are in the wrong training, if that's not a case that you will be doing this summer, okay? But I think for most of you at Akin Gump is VAWA self-petitions and hardship waivers. And I think there's a few from Allen and over here as well, right? So, so I am the Akin Gump mentor for Her Justice, and Amanda Doroshow is the Allen and Overy mentor. And all of our contact information is at the bottom, back of the, I think it's at the end of the training. But in any case, again, this is a long training. We're going to talk a lot about things. I will be going pretty quickly through some things, and but slowing down if need be. Please ask questions throughout the training, okay? And here we go. So you saw in the video what our mission is, who our clients are. We work in family court. We do cases in Supreme Court. Those are matrimonial cases. Family court cases are orders of protection and child support cases, as well as visitation and custody cases. And then we do immigration cases in front of the United States Citizenship and Immigration Service, and those are for U's, VAWAs, and T's, and we'll talk a little bit about that in a bit, okay? And so again, who are clients? 80% are survivors of intimate partner violence, 71% are mothers, 67% are foreign-born, and the way they find us for Her Justice, it's through the Family Justice Centers that is run by the Mayor's Office to combat domestic violence. And then we also have a Her Justice helpline. Here's the phone number, and it's open. Actually, there's a typo here. It's not Thursdays, but it's Tuesdays. Okay, so today, the purpose of today's training is to provide an overview of what we do, and then about the immigration issues facing our clients. We're going to talk about how to work with your clients who are traumatized and unfamiliar with the legal system. We're going to be talking about a very, very limited piece of immigration law under the VAWA Act, which is the Violence Against Women Act. Okay? And then within that, I'm going to talk to you guys, or we're going to talk about how to prepare and file a VAWA self-petition case. We have manuals. The manuals are currently being finalized, so you probably did not get a manual. If you do have a manual, they're a little outdated, so wait a couple of days. We will be sending you the newer manuals. So before we go totally into immigration law, we're going to talk a little bit about domestic Violence 101. Because all of the VAWA cases, the Violence Against Women Act, as the self-petitions, as well as hardship waiver cases that you guys will be dealing with are all clients who have experienced some sort of intimate partner violence. Okay? Can I just have a show of hands of anybody worked with domestic violence survivors in the past in any kind of case? Oh, good. A good number. Nice. It's always nice to see. And so what is domestic violence? It is a pattern of coercive and abusive behaviors used in any relationship to gain or maintain power and control over another. That is the definition of it, right? So what you need here is a pattern and it's control to maintain control, power and control over another person, okay? And the goal is fixed imbalance of power. It's not a one-off incident. It's not like, oh, I was assaulted by somebody. Okay, that's not domestic violence. It's somebody who's in an intimate partner relationship with me. It can be my intimate partner as like a spouse and or a girlfriend, boyfriend, or it can be my parents, right? Or my children might be abusing me, I might be abusing my children, or something like that, right? So it's got to be an intimate partner thing. When we look at domestic violence in the immigration spectrum, it actually goes a little bit further than just hitting or verbal abuse. It can be using other kinds of coercive tactics. You're talking immigration, status. I can say, hey, I have immigration status, you don't, so I have the power over you. If you don't do what I say, this is going to happen. I'm going to call the police. They're going to come. They're going to arrest you because I'm the U.S. citizen or I'm the one with papers. You don't have that. So immigration status is one big issue. Other forms of domestic violence can be sexual abuse, economic abuse, social abuse, isolation. Social isolation is big in the immigrant communities. Saying, okay, you have to stay home. You can only talk to people I want you to talk to. You can only talk to my immediate family. You cannot talk to anybody else, keeping them in the house under lock and key, saying, oh, you don't know the language. Oh, and it can be under the guise of, oh, you don't know the language. Who knows what's going to happen to you when you go out, right? But it can turn more into a controlling factor. Okay? And we'll see some of that later. Okay. So the effects of domestic violence, again, there's health-related effects, there's physical, sexual, mental. Obviously, there's also a lot of our clients are in shelter because they had to leave. There's some substance abuse going on. There might be some psychological issues that our clients are dealing with as well. And we'll talk a little bit about that and how to deal with that. If your clients need counseling, and they're not in counseling, please give us a call. Give your Her Justice mentor a call and say, hey, look, I think my client would like some counseling. Can you provide a list? And we will give you references, okay? Otherwise, some of them are already in counseling. And if you think that it would be good to talk to their counselor, you can do that. Get a release from her and then actually talk to them as well. So when you're working with domestic violence survivors, many of you have already done this, right? And worked with domestic violence survivors. The thing that you have to remember is to be patient and non-judgmental. A lot of clients may come to you with a totally flat affect. And you're thinking, oh my goodness, you've been through so much. I read your case opening report. They say you were sexually assaulted on a daily basis by your husband or whoever, and you have no emotion, okay? That happens a lot. And in those kinds of cases, again, you have to be patient and non-judgmental. You have to build that trust with them. That's number one thing, is to build the trust with your client. And that's going to be done in the first meeting, the second meeting. As you keep going, you're going to start building trust. They might tell you things, not tell you things that first meeting, and like 5 meetings down the line, you're already done with that affidavit. You're sending it to me, and I'm thinking, okay, this is great. And you call me and you say, oh my gosh, she just called us, and she just told us this whole new story, right? And that happens a lot. So again, you need to be patient, non-judgmental, and acknowledge your own emotions as well as what might be happening. A lot of our associates, a lot of us who work in this field have a lot of vicarious trauma that comes to, like, listening to these stories day in and day out can leave you with some, disturbing thoughts, and you're thinking, oh my goodness, I can't do this, I can't meet with her. I mean, acknowledge your own emotions as well, and if you feel like, okay, you know what, I need to take a break, take a break. These meetings with your clients will be long. They will take 2 hours, 3 hours sometimes. Make sure that you build in breaks in there for yourself or your client, just to be able to regroup and kind of redirect things. Okay? Again, building that trust, explaining your role, and again, encouraging use of DV support services if she needs it. We do have a DV 101 video on YouTube, so you can watch that. It's a little bit, I think, half an hour of more in-depth of like how to interview your client, talking to your clients, things like that. Okay. So, any questions on the DV piece? Okay. Again, a lot of your clients have, all of your clients have been screened by us. They've spoken to us already. We've done a little bit of safety planning with them. We've talked to them about counseling services. But if they say, hey, look, my situation has changed. Some of them are still living with their abusers. If their situation is changing and they want to move out, give me or Amanda a call and talk to us about that, okay? And we will talk. Yes?
Why does the definition of domestic violence require that there be more than a single instance of abuse? And have you ever seen a case where, for example, one very violent instance created a pattern of fear, but not necessarily a pattern of more violence?
Yeah, so the domestic violence incident, when I say it can't be a one-off incident, it means one-off physical incident without the more. See, that, what you just described, is domestic violence because there is more, right? He or she, there was a big significant event, and then after that it was like, remember what I did to you. That fear, that control that you have, that is what domestic violence is. It wouldn't be like a one-off of like, okay, I hit you, I'm so sorry, I'm never going to do that to you, and it never happens again. It's never brought up again. They don't like kind of emphasize it and say, remember that time. They don't do that. There's no control with that one incident. That would be that's where you're going to have a little bit of problems trying to prove to immigration that this is a domestic violence case. Okay, so in this specific example, absolutely that is domestic violence. If there's a one-off incident which is so severe, and from that she's just terrified or he's just terrified of doing anything else, right? And that person just keeps the abuser brings it up over and over and says, remember that. I had a case where he threatened to kill his wife, and then he brought a big duffel bag and said, I'm going to kill you, chop you up into pieces, and put you in this bag. And then since that time, he left the bag in the corner. And anytime they got into an argument, he would say, hey, look, and he would just like point at the bag, and she would just totally, have to just succumb to whatever he wanted. So those types of incidents are that's domestic violence, and you could use that. Right? Okay. So here we go into immigration. Again, this is a very, very, very small piece of immigration law. Immigration law is extremely complicated. Apparently, it's some famous justice said, it's the second most to tax law is immigration is the most complicated. And but again, this is a very, very small piece that you guys can all understand, all digest, and all be able to, at the end of the summer, be able to send off your immigration case to USCIS, okay, for your client. So the administrative structure of immigration right now it's all under the Department of Homeland Security, at least within domestically, it's under the Department of Homeland Security. You have got Customs and Border Protection, Citizenship and Immigration Service, Immigration Customs Enforcement. Customs and Border Protection are the people that you show your passport to when you're coming in at the border. either at JFK, LaGuardia, wherever, boat, by land, you're showing this to CBP, okay? That's who looks at your visa, says, oh, you have an entry here, thank you very much, here's your stamp, go on in, okay? That's CBP. And then Citizenship and Immigration Service, they are the adjudication arm of petitions. So all of your petitions will be sent to CIS, USCIS, okay? And they are in different service centers. There's Vermont, California, Texas, Nebraska. Depending on what kind of petition you're filing, you're going to be sending it to a certain service center. All of your petitions will be sent to the Vermont Service Center first, okay? And then from there on, like the Vermont Service Center may be sending it to other places, but all VAWA related and hardship waiver related cases are sent to Vermont Service Center. Okay? And then the next piece, ICE, the Immigration and Customs Enforcement, these are the people that come and do the immigration raids, right? You've all been hearing about these lately, about them coming to homes, schools, what have you, everybody's scared. And so these are the folks that do that. And when you look at immigration, then we go from who's adjudicating to immigration categories. What are the immigration categories that we look at? There's a non-immigrant. Non-immigrant are who? People who are here for a short sojourn, right? They're here for what? Work purposes, but they're not here permanently. They're here for school, okay? They're here to visit. They're here as a crew member. Whatever it is, it's not permanent, it's temporary. They're going to leave without, within that allotted time that they have under their visa, okay? And then we have immigrants. Immigrants are people who are here to live permanently, who want to be here permanently, okay? And they're here for lawful permanent resident status with a green card by permission from the U.S. government, okay? And then we have citizens, right? This is in the spectrum of, immigration categories. Citizens are people who are born in the U.S., birthright. Naturalization, people who are here, they immigrated here, and then they become naturalized U.S. citizens. And then there's acquisition. If your parent is a U.S. citizen acquisition is if your parent is a U.S. citizen, you're born abroad, that's acquisition, okay? You're a U.S. citizen born abroad. Derivation is when your parent becomes a U.S. citizen before you're the age 18 and you derive citizenship through that. Okay. And so any questions on that? The categories of immigration categories? No. Okay. Ways to obtain lawful immigrant status. There's family. This is the way most people will obtain lawful immigrant status, lawful permanent residency, green card. Then if you're a non-U.S. person, this is how you're going to get this, right? You're going to get it through family, through employment, visa lottery, or humanitarian grants. Family is what usually most people will get it through. If you're, brother, mother, sister, not your aunt and uncle, not your cousins, but your immediate relatives can sponsor you. And then employment, if you have an employer that says, hey, I need this person, I really, really need this person is the only one that can do this job for me, they can sponsor you to do that. And then there's something called the visa lottery. Visa lottery, U.S. government decides, oh, you know what, we need more people from this country or this region, and people put their applications in. It is really like winning the lottery. You get picked, you're lucky, you look at it, you think, oh my goodness, this is great. And a lot of people from Eastern European countries in the early 90s, mid 90s got the visa lottery. They came through the visa lottery. There are a few folks that are still recipients of visa, that I know of, that are recipients of visa lottery from Western European countries, and some from South Asia as well. Okay. And then there's the humanitarian grants. Humanitarian grants are what we're looking at, the U, the T, the VAWAs. Okay, those are the ones that are for special reasons, right? Because of humanitarian reasons, like U.S. government says, okay, we should let these people in under these certain circumstances. So, impact of the executive orders. I just have to throw this in. We have to talk about this a little bit because what happened in November and January is impacting the lay of the land right now as we know it in immigration land. So what happened? In early January 25th, January 27th, the Trump administration put out some executive orders that made everybody go a little bit nuts and a little bit scared. And what they did was they created enforcement priorities, include people who have any criminal convictions, charges, or committed any criminal acts. And they've also, and then also to anybody who's engaged in any fraud or willful misrepresentation. And then it's also required the prompt removal of anyone whose legal claims to remain have been denied, and also to detain anyone apprehended for violations of immigration law until their removal. So these laws have always been on the books. They just haven't been enforced, really. People in President Bush's administration as well as President Obama's administration, these laws have been there for a long time, except for they thought these people aren't enforcement priorities. Not everyone's going to be an enforcement priority. We're looking at violent criminal offenders, not people who have overstayed their visa. But under the new enforcement priorities, people who have overstayed visas, people who might have minor infractions have all become a criminal. Minor, like you saw in that video, Daniel was talking about his client who got picked up by NYPD because her abuser called. Okay, she pled out, and that made her a criminal. She had a criminal record because, you know, she just wanted to get out, and she pled to disorderly conduct, but again, she has a criminal record now. So it makes people like that a criminal, and that's where it's a little bit problematic. And then the detention of anyone apprehended for violations of immigration law until their removal. Again, that's why you're hearing a lot of things in the media as well as probably in the community saying, oh, did you know that so-and-so got picked up, and this lady who went to family court to get an order of protection got picked up because she had an old order of removal, et cetera, et cetera. You're hearing all these things. Some of it is true, some of it is not true, but again, there's fear in the community, there's fear within your clients. We have all, during their initial screenings, during their initial talks with us, we have talked to them about what's going on in immigration land right now. They're still scared. If they ask you more questions, if you think, it'd be better to talk to us, give us a call and we'll talk to you about more of their rights, what they should do. If anything happens while while you're preparing the petitions, give us a call, right? They might get picked up. They might have old orders. I don't think any of your clients here have old orders, but if they do, just give us a call. We'll talk about it. And again, filing these, having something pending with Immigration Service is better than nothing, okay? And we've done thorough screenings for for all of your clients to make sure that they do have a good case, okay? If we feel like they didn't have a good case, we would have told them, hey, look, it's better not to put yourself at the attention of immigration if necessary, So again, all of your clients do have good cases, and if they do call you and talk to you about and want to discuss some of these, the issues that are maybe happening, just give us a call and we'll be more than happy to talk to you guys about that. Also, there's going to be an in-depth training on this. We're just talking just about the executive orders and family planning and things like that. No, it's kind of more of a lawyer's teach-in that we're doing at Sherman and Sterling, and that's going to be on June 28th, okay? And we'll let Rachel and the people here at Akin know about that. So if anybody's interested, that you guys can come to that, okay? So any questions on that? All right. So obtaining immigrant status, here again, we're going to compare these two things only, the family and the VAWA process, because the VAWA process is very akin to the family process of being sponsored by a family member, except for you're doing a self-petition, okay? So it's always a two-step process. Step one is to get some kind of acknowledgement from the U.S. government, from immigration, to say, oh, you have a relationship, a valid relationship with somebody that will allow you to then adjust status and become a lawful permanent resident to get your green card, right? So usually, again, for the petitioning, when you're doing a family petition, the family member will file Form I-130. Usually, in this case, it would be the husband or the spouse would file the I-130. And then the second step is, and once that family relationship is established, then you file the I-485, which is the adjustment of status, okay? stage, which is for your green card, or consular processing if the person is abroad in a foreign country. Okay? And then for the VAWA self-petition, though, instead of the spouse or family member, because it's not just, VAWA self-petitions don't have to be just spouses, okay? It could be parents and children if they're parents of abusive U.S. citizens, and or the vice versa if you're a child of an abusive U.S. citizen parent, okay? So you could do it that way too. So self-petition, again, instead of the family member filing for you, you're doing it on your own. Okay, you're petitioning for yourself. That's why it's called a self-petition. And it's a different form. It's a form I-360. And then the second piece is the same. It's an adjustment of status. You're going to ask the U.S. government to adjust your status to become a lawful permanent resident, or you will consular process if you are outside of this country. Okay. Okay, so the benefits of doing a self-petition, the self-petitioning process, is that the self-petitioner is in control of the application process. You don't have to rely on your abusive spouse to say, oh, are you going to do this for me? When are we going to do this? Are you going to, that's where a lot of abuse starts, right? Oh, I'll do it for you if you do this. I won't do that for you if you don't do this. Oh, you didn't do that, so I'm not going to do this today. And if I do it, then you have to do X, Y, Z, right? So there's all these strings attached in an abusive relationship when you're talking about immigration. So the benefit is that the self-petitioner is self-reliant on herself. She doesn't have to deal with it. Somebody else doing it for her, relying on that other person, okay? And the other thing is, there are safeguards of confidentiality. Under the statute, USCIS is not supposed to rely on anything an abusive spouse says, okay? So a lot of times what happens is we will file something and the abusive spouse finds out that we have filed, and then he will email or call and or send a letter to USCIS saying, oh, this is total sham marriage, she's lying about this, we never got married in good faith, et cetera, et cetera. And, but USCIS is not supposed to rely on that information, okay? So there's confidentiality built in. USCIS is not supposed to share any information with the abusive spouse that this person has filed this. They won't even acknowledge that they've received it, okay, to that person. And then it also, doing the VAWA self-petition, you can get work authorization and economic independence from the abusive person.
There's also getting sorts of social services, like a social worker, a case manager.
So once you get the prima facie determination, you do have access to public benefits and some, social services if you need them. And we'll talk a little bit more about that later. So once you file it, you get a receipt notice and a prima facie determination saying on its face, this is all good. You can apply for some social benefits. New York City, you could do state and federal benefits. Okay. We're going to talk a little bit about a case study here. It's a hypo, and we're gonna use this hypo so that you guys can get more into it. The hypo is not written out, so please pay attention and listen carefully. Okay, we did this on purpose because before we used to write out the hypo, and everybody was just so busy looking at the hypo that and this gets you to listen a little bit more. Victoria is originally from Ukraine. In 2009, she met Sergey when he was visiting family in Ukraine. After Sergey came back to the United States, the two kept in touch via Skype and email. Victoria came to the United States on a tourist visa and decided to stay and moved in with Sergey. Since she didn't know many people in the U.S. and hadn't been to the U.S. before, Victoria relied on Sergey for helping her get used to living in the U.S. Sergey went everywhere with her. Even after 6 months, when Victoria started taking English classes, Sergey insisted that he take her to the classes and pick her up afterwards. He asked her about the friends she was making and who she was hanging out with in school. Sergey would look through her phone and contacts to see who had called her and whom she had called. Victoria started to limit her calls home to Ukraine because Sergey told her that he could not afford to keep buying her phone cards. Soon she was only talking to her parents once a month, and Sergey insisted on either being in the room or talking to them as well. Outside of her English classes, Victoria could only leave the house if Sergey was with her because she didn't have a key to the house. Sergei told her that he didn't have an extra key for her and could not make one for her because the landlord would not allow it. Therefore, during the day when Sergei was at work, Victoria had to stay in the home. Victoria often feels lonely and helpless. Victoria and Sergei eventually married in 2011. Sergei has promised to file her immigration papers for her, but has continued to put it off, saying that they don't have the money right now. However, whenever the two argue, he brings her status up to say that she is illegal in the country, so she better watch out. Sometimes arguments have gotten physical, and Sergei has pushed and shoved Victoria. Once, when Sergei slapped her across the face, Victoria pushed him back and kicked him to leave her alone. Okay, so if you look at Victoria's situation, would you say that there is domestic violence here or no? Yes. What kind of domestic violence is there? Isolation? Physical? Immigration privilege? Economic? Anything else? Right? So yeah, those are the main ones that's showing up here, right? So, using Victoria and Sergei, we're going to go to see what are the self-petition requirements. Okay? So there are basic requirements for this, and to actually file for VAWA relief. Abused spouses of lawful permanent residents and U.S. citizens. Okay? And you can include people can include their children as derivatives no matter where they live, here in the United States with them or abroad in home country. Okay? The other people who can qualify are non-abused spouses of USCs and lawful permanent residents where child is abused. Okay? If my child was abused by a lawful permanent resident or a USC's husband, I could apply. Okay? Abused children of USCs and LPRs, or abused parents of adult USCs over 21. Okay? So, what are the elements? Immigration status of abusive spouse has to be a lawful permanent resident or a U.S. citizen. Okay? The abuser's status has to be a lawful permanent resident or U.S. citizen. Okay? Legal valid marriage to this person. Okay? If you're doing it against a spouse. There has to be good faith marriage. We're going to talk about all of these and what this all means in a minute. There's got to be shared residence. There has to be some kind of qualifying abuse. Okay, battery or extreme cruelty. And there has to be good moral character. Good moral character means it's generally a look back of 3 years to make sure that your client was not convicted of any kind of crime that would make her have bad moral character. Okay, good moral character is kind of weird. There is a definition of good moral character in INA, which is the Immigration Nationality Act 101F, if you want to look it up. So if you go back to Sergei and Victoria, do you think she would qualify? Would she qualify?
I mean, Sergei's an American citizen, I assume. We didn't clarify that, though.
Exactly. We don't know what Sergei's citizenship is, right? We don't know his status, but once we clarify that, then she could probably apply. Okay. So how do you prove? I'm sorry, I can't see what's. Okay. So how do you prove immigration status of abusive spouse? If they have a U.S. birth certificate and your client could get her hands on it, okay? That's one way. Passport, if she's seen a passport. Other immigration documents. If he ever filed anything for her, he would have had to put his, if it was an I-130 filing, he would have had to put, and he was a naturalized U.S. citizen, then he would have had to put his A number in there, okay? Or she might see his naturalization certificate. She may have seen that. Other official documents. Guess what? The New York State marriage certificate has people's place of birth on them. Okay? So if he was born in the U.S., these are the hardest people to actually get U.S. To get proof of, are people who are born in the U.S., never ever traveled outside of the U.S. and never got a passport. Because you can't ask the immigration service, can you look this person up? I know he has a passport. I know he has a he's traveled, I've seen it. You can't do that because they don't have any record of him ever getting that. So the people who are born in the U.S., never travel, never get a passport are the hardest people to actually prove immigration status for. But again, other official documents may have that information, like marriage certificates have it, birth certificates have it, children's birth certificates will have that as well. So those are other places that you can look. Okay? And then the last resort is you request USCIS to search records. Yes.
For the marriage certificate, is that's something that is reliable? Like, it's not self-reported where they were born. It's like official.
I mean, it's official, so yeah. I mean, they might self-report where they were born, but usually people, I don't think.
But it's typically not.
Yeah, it's typically, yeah. So I've never gotten questioned when I use that as.
What if the client knows her abuser's social security number? Does that count?
So the social security number, does that count? It helps, but it's not a definitive, hey, because a lot of people with social security numbers may not have status. They might have a different kind of status, and it might not be lawful permanent residency or U.S. citizenship, because people who are working here under other visas can get a social security number.
No, so if our client does have the social security number, can we ask the authorities to look up the status?
Yeah, so that's what the last one is. Request USCIS to search its records. Yes, you could say, this is what I know. This is his date of birth. This is his social security number. This is when I think he may have naturalized or entered the United States. This is all the information I have for him. So please look this up. It is under the statute that USCIS must look at their own records to verify if we can't verify it ourselves, okay? And if your clients are in that situation, let us know, and we have a boilerplate like language that we do submit to USCIS when these kinds of situations come up. But it's amazing what your clients will know or have seen, and they know they've seen it somewhere. So they'll say, I know I've seen it. I mean, so just ask them, hey, do you remember, can you search your like maybe it's in your emails, maybe it's something that he filed for you, maybe it's something that he was showing you to show off or something, maybe somewhere in there, you can look for it. But we do tell clients to please be careful when looking for this stuff, because obviously it can put them in danger, especially if they're still living with them and they're going to be rifling through, and that might pose a problem, okay? A lot of times our clients show up with his passport, his everything, and it's like, but you're separated. She's like, I know, I took it all. And then you say, well, you have to return this, okay? I mean, it's like, it becomes this like, they're very, very proud when they leave with all the documents, but again, it is his. So like once you make the copy, then we definitely say you should return this as soon as possible. Okay, so that's how you prove. Again, we didn't know Sergey's immigration status, but if he was a U.S. citizen or a lawful permanent resident, we could probably file this VAWA self-petition for her. And again, we're going to prove it in different ways. Yes.
So I was just wondering, in this Victoria and Sergey scenario, she most likely needed a visa, which initially when she came in 2000, right? So he would have had to be the guarantor.
Maybe.
And then if he provided that information to the U.S. consulate, he would have access to that.
So it depends on which country you're coming in from that you need a guarantor or not. Some countries you could get it pretty quickly, or there's visa waiver countries, they come in without a visa because we have this mutual agreement, although I think that is all kind of flittering away recently. So it depends on what country they came from that they may have that. However, getting information from the State Department is almost impossible. They won't tell you what was submitted in a visa application, or if a visa was denied, why it was denied. They're very, very, unless it's an adverse decision that they're going to use against you, they're really, really reluctant to share any information, and it does take a long time. So I wouldn't try to rely on the visa application necessarily. Okay, but good idea though. If all else fails, that's something to do. Okay. And then she has to prove legal valid marriage. That's an easy thing to do, right? You just prove that you show there was a marriage in a jurisdiction here in the U.S. or in some other country, okay? That's all you need to do. Even if it was like a tribal ceremony or something like that in home country, right? But if it's a valid and legal in the place where it was performed, it is valid and legal in the U.S., okay? So, yes?
If the client, I think our client doesn't have papers to
So, yes, there are other ways to show it. Again, if it was done here in the U.S., then you can, you know, obviously she has rights to get her marriage certificate too. A lot of people think that, oh, he has that marriage certificate, can I get a copy of it? Of course you can go to get a copy of it. You can go to this county clerk's office and say, hey, I want a copy of my marriage certificate, and they will give you a copy of it, okay? Yes.
Sorry. Suppose they were living in a state where like common law marriage is recognized and then here it's not, right?
Yeah,
So,
in New York, it's not, common law is not recognized, but if they were, so I'm gonna answer this question and answer this question too at the same time. If it's like a common law marriage, right, you can prove, like, say that it's, I don't even know what state in the US common law marriage is recognized, but say that it is X state, and X state recognizes it, and all you have to do is pull up, you know, their statutes in that state's law saying that this is common law marriage, is, you know, in this state, like domiciled for like however many years means that you're married, and just put that in and say, and that's going to be part of that affidavit, right? So it's common law marriage. But say that she has no papers at all, but it was an official marriage done in home country, right? So first we tell people, okay, go to the consulate, try to get this through your consulate, okay? Some places don't have a marriage certificate, but they have family census registries, okay? Places like in East Asia, like Korea and Japan, they have family census registries where the person is just inserted into somebody's family census, right? And so they can get a copy of that. They could try to get a copy of that and things like this. Say that it's a total like weird, not weird, but a traditional marriage that's done in a tribe, like in the village somewhere. Again, if she can say, look, this is the way it's done, this is our tradition, and somebody else can vouch for her and say, like, yeah, I was there at that wedding, and this is the way it's done, it's all good, okay? The marriages that are not valid, for example, proxy marriages in a Muslim marriage is not valid, okay? You cannot have somebody on the telephone and you somewhere else, and you can't have that proxy marriage, okay? It doesn't work. So it just depends on the culture and the laws of the country where it's happening, okay? So if you have a situation like this, talk to us, and if it's not clear-cut that there was an actual valid legal marriage. The other piece to show in a valid legal marriage is that you are divorced from any other marriage, right? So if your client was married before, she must have the divorce certificate from her prior marriage, okay? Her husband may be divorced from somebody else as well. Does she need that? No. Okay? She does not need to prove that he was divorced. She can just say, I know he was married, he said he was divorced, and I believe him, whatever it is, right? Because there's something called the bigamy exception in the VAWA statute, in the VAWA laws. The bigamy exception is not my bigamy, but my husband's bigamy. It's not my fault. He didn't tell me, he swore to me up and down that he was divorced. Fuck, turns out he wasn't. I was wife number 3, okay? And he didn't tell me this, whatever it is. But it's okay, because it wasn't your bigamy. You didn't know that. He told you, and you totally believed him, thought he was not married, thought he was, you know, divorced. Lo and behold, you come here, and then some stranger knocks on the door and says, I'm his wife, what are you doing here, right? That happens, okay? So again, there is a bigamy exception. So she does not need to prove that he was divorced, but she needs to prove if she was divorced. Any questions on that?
So if our client is a man,
Mm-hmm.
he would still have to prove the wife was divorced.
Yeah. No, if your client was a man, no.
You don't need to.
Yeah, it's just, yeah, it's like whoever is filing needs to prove that they were divorced, okay? They don't have to prove that their spouse was necessarily divorced. Does that make sense?
But you don't mean to the person she's filing as in if she had a prior marriage.
Yeah, yeah, yeah.
Uh-huh.
Yeah. Because you can still be married, still be living together when you file the VAWA petition. Okay. Okay. This is USCIS's favorite thing to stick to and to try to disprove that your client did, which is good faith marriage, okay? So you need to prove that your client married her husband in good faith, meaning it's intent to establish life together for any reason other than purely to establish contractual relationship to obtain an immigration benefit. Okay? That is immigration's definition of what a good faith marriage is. you have to have a marriage that is not for the sole purpose of immigration benefit. Immigration benefit can be a purpose, but not the only purpose, okay? Because this is all about immigration fraud. Sham marriages, immigration fraud. I'm going to say, hey, I'm going to pay you $10,000 if you marry me and get me my green card. And then we're going to get divorced and everything's going to be fine, okay? So they want to prevent this. So that's why they have this. It has to be in good faith, a good faith marriage. And the standard of proof for good faith marriage is preponderance of the evidence using any credible, relevant evidence. Okay, that is the standard. It's any credible, relevant evidence. So, how are you going to prove this? The self-petitioner's affidavit is key. Your client's affidavit is key. You're going to work with your client on many, many iterations of her affidavit of why it was a good faith marriage, okay? The thing is, by the time your clients come to you, they are either very angry, they've already left the situation, or they're still living, okay? So they're not really thinking about the happy times or why they got married to this person. And this is where you're trying to get them to show the good faith marriage, right? If they have children, that's easier to prove. Hey, we have a child together, so there's that intent that we wanted to do this life together. But again, if they have no children, what are you going to try to do? Bring them back to the happy times. How did you meet? What did you meet? What did you do? Immigration wants to know the nitty-gritty, mundane details of courtship. They want to know, what did you do during your courtship? Where did you go? How many emails did you exchange? How many times a day did you talk on the phone? And they will, when you get an RFE, which is a request for evidence, on the sticking point as good faith marriage, they will try to glom onto anything they can to show that your client did not marry her husband in good faith. So what you need to show is that she did marry this person in good faith. The best scenarios, or the easiest ones, are the ones where it's an arranged marriage, okay? Because there is no wiggle room there. It was an arranged marriage. Of course it's a good faith marriage because parents here decided we're going to get married. We got married in 1 week, but still it's a good faith. The cases where we see the most difficulty are the ones where they've been dating for 7 years, and she was in home country, he was here. They saw each other every once in a while, right? But then there's like some periods of not talking to each other. They have very little photo records of anything, maybe because he took it all. They have nothing really to show that there was a real relationship. That's where USCIS kind of gets really stuck on things, okay? If you think about the adjudicators, who they are up in Vermont and Nebraska, and have that mindset, right? If I'm a person up in Vermont or Nebraska reading this, am I gonna believe that this romantic relationship really happened if they've only got one picture and nothing else? If you're like waxing poetic about how romantic this thing was, right? So think about that and think about how you're going to present your case to USCIS. Because on the VAWA case, it's all done by paper. They're not going to interview your client. She's not going to have a chance to sit there and say, I swear to you this was a good faith marriage. She's not. It's all on paper. It's all on what you present. You control that record for them. So as much as you can, you're going to ask your clients, hey, do you have emails? Email exchanges, Skype exchanges, whatever you did with him. Did you take like pictures? What have you? Get those things from your client. However, there are clients that don't have any of this. Why? Culturally?
No.
Huh?
I was thinking like the fist in the ring and everything.
That is true. That happens too. Do you have pictures? I did. Guess what I did? I deleted every single one of them. Okay. In this day of technology, there's something called the cloud. Things get saved automatically, right? Even if you don't want it to be saved, things get saved, uploaded, what have you, if you have an automatic save function. Tell your client, hey, can I go through your phone maybe with your permission, and let's see if we can find some things here, okay? That might work. Because again, some clients, if they only have like physical pictures, yeah, they burn things, they throw things away, they rip things up, okay? So if they don't have anything because of that, or he may have controlled everything. right? Culturally, they may not have taken any pictures. Culturally, it was just, hey, he controlled all of it. Bank accounts, all those things, he controlled it all. So you have to explain why you don't have something. If you don't have a piece of evidence, you have to explain it in that affidavit. That's the most important thing. We don't have this because. Although we were dating for 6 years, I don't have any pictures during that time because. And say why. And make it a reasonable explanation of why. Okay? Yes.
Can an affidavit of a disinterested third person be used as?
Absolutely. You can have an affidavit of third parties. We have supporting affiants all the time. Supporting affiants who can attest to one part of the element, but not the others, right? I have a friend who was always with us on dates. She introduced us. So she can be my good faith marriage person. But I never talked to her about the abuse because I felt bad. I didn't want her, because she's also his friend. So I never wanted her to know. So I didn't talk to her about the abuse part. But she can talk to all about the good faith marriage, how she introduced us, how she was at our wedding, how everything seemed great. Okay? Get your client's permission to get those supporting affidavits. You will make a list, and it's in your manual as well, but at your first meeting, what you're going to do is you're going to make a list of supporting affiants, things that may be lacking, and how you're going to fill those holes. Okay. Any questions on the good faith marriage piece? Again, this is a huge piece. So, and then the next piece is proving shared residence. And this can kind of go with a good faith marriage. If you have a good faith marriage, you should be living together. You have to have lived together, even if it was for 1 week, 2 weeks, 5 days, whatever it is. You have to have some sort of joint residence. And we have won cases where it was less than a 2-week joint residence. Why? Because right after they moved in, guess what? He hit her so badly and tortured her for however long it was, and continued to do so that she moved out. It was so bad that she moved out. Okay? So it works, but you need to show some kind of joint residence. How do you do that? Again, with affidavits. If you do not have joint leases, joint bills, you're going to say, I don't have this because he never put my name on the lease. He told me that I couldn't do it. In the case of Sergey and Victoria, would she have a joint residence?
Maybe when she signed up for school?
Maybe, yeah. Maybe she put her address there. That's a good, you look at school records, kids' school records. Anything that shows,
Mail.
She may have got mail. So mail sent to the address, it could be addressed to 2 different people, him and her. It doesn't have to be jointly addressed, but you could show that, hey, there was mail addressed to me at this address, there's mail addressed to him at this address. So we live together. This was my established address. Okay. I had a case where it was, this is years ago, but where he put her up in an office building, in the back of his office building. And he came like 4 times a week. Maybe he didn't really live there, but he came 4 times a week to torture her, to rape her, to just do all kinds of crazy things to her. And, but she didn't have it was an office building. She didn't live there. She couldn't really show that she lived there. There was no physical evidence that she was living there. So in her affidavit, she said, he put me in this office building at this place, and he came every single night and did this to me and stayed the night and then left. Right? And that was approved. And that's how we showed the joint residence. There was no actual physical marital home, but some kind of, place where they both stayed for a period of time is what you need to show, like that they were living. Okay. Any questions on that? Okay. So again, and then you have to prove qualifying abuse. That's the next piece. The easier ones are proving his status and the joint residence. The harder things are the good faith marriage and then the qualifying abuse. The more subjective pieces of the elements are going to be a little bit harder to prove to USCIS, and this is where you're going to be putting the bulk of your efforts. So proving qualifying abuse. Again, it could be acts of physical abuse, threatened acts of violence against victims or family members. forceful detention, sexual abuse, rape, molestation, forced prostitution. And then there's extreme cruelty. If you don't have the physical, okay, that's okay. You don't need physical abuse to prove this. You can have extreme cruelty, which is social isolation, economic abuse, stalking, accusations of infidelity, verbal abuse, degradation, denigration, threats. However, one thing our clients will kind of get really stuck on and say, oh, this is extreme mental cruelty, is that he cheated on me. I think that's extreme mental cruelty. How many of you would say, yes, that is extreme mental cruelty? Somebody cheated on me. My husband cheated on me. Good. I'm glad that you guys are all skeptics like me. So if she comes in and says, he cheated on me, that's my extreme cruelty, and she just keeps talking about that, and that's what she's stuck on. The thing is, USCIS will look at that and say, this is a bad marriage, but not an abusive marriage. He yelled at me, I yelled at him, we argued constantly. That is a bad marriage, but not an abusive marriage. That's what you have to show the difference of. He cheated on me. How can that be spun to be abusive? He cheated on me and told me, I go out with other women, I sleep with other women because you will not do this for me, because you are a bad wife, because I do this. So you can spin it if he has been psychologically and verbally abusing her while going out, and to make up his own excuses of why he's doing what he's doing. Because you don't cook properly for me, I go to her house to eat dinner and have sex with her. Because you're a bad mother, I'm going to have children with this other person. Okay? So that's how you're going to spin that. Yes.
In the interview with the client, if the client is stressing a mutual argument, something that you don't think is evidence of this, do you suggest any strategies for turning the conversation? Do we explain that to them, or do we?
Yeah, you can explain it to them. I mean, I think if you explain it to them in the way of, hey, you need to show to immigration that it's not a bad, like your marriage wasn't just a bad marriage, that there was some kind of control. So yes, a lot of our clients, I mean, not all of them are going to be docile and just sit there and take it, but it can be a mutual fight, right? Mutual angry, everybody's yelling, and then all of a sudden he hits her, and then she stops. That's how he always controls her, right? It's like she can start being annoyed about something, and then immediately, like when she's annoyed, he's like comes in with full force of something else. So that's what you want to show, right? And a lot of our clients will say, well, I yelled at him because he was drunk again and he was passed out. And when I yelled at him and I shoved him because he was doing this, he got angry and went and did this, right? So and so you want to kind of minimize what she did and kind of maximize what he did in terms of the bad act. But yeah, that's what you would need to show. Okay. Any questions? Yes.
Can the threat be to anyone, say not her, but maybe like some family back home?
Absolutely.
Okay.
Absolutely. It could be a threat to family back home. We've had that situation a lot. I'm going to have my friends in home country cut your brother, sister, mother up and send it back to you in pieces. Okay?
Is her account of what happened 100% like reliable for immigration, or they want like objective evidence?
No, it's all reliant on her account. Okay. So that's why they won't use. They're not supposed to be using his any information from him. However, her account is supposed to be reliable. This is why when you have supporting affiants, you have to make sure it all corroborates. All the stories kind of work together. You can't have some major event happening in April for your client and the same event happening in May for her supporting affiant, because they're going to say, okay, then nobody is reliable here.
So how about if you have like objective or official evidence that conflicts in some way? Is that to be explained in the affidavit, just not submit something if it's going to be confusing?
Absolutely. So there was a case at Akin Gump a couple of years ago where it was the client was kicked in the face 6 times. She was bleeding, and she said that in her affidavit. However, the police report says aren't always accurate. The police report said client states, petitioner or party 1 states she was kicked in the face 6 times. No visible injury is what they checked off. Immigration came back and said, we're going to RFE this. We don't believe you. What's going on? She doesn't seem credible if you have this official evidence from the NYPD that says this. And so their attorneys here wrote back and said, look, don't know why they said that. It's a clerical error because obviously this is what happened. She was consistent in all of her stories, and her supporting affidavits were also consistent with this story. And they got a denial on this. It was ridiculous. So then we went up the chain a little bit more and said, and then, you bring in other evidence, like how police reports aren't always reliable. You have to bring in other extrinsic evidence for that to combat this stuff. But so if you see something that's totally off from what your client said and the official something is saying something totally different, you have to kind of try to damage control that up front and say, the police report I know says XXX. However, this is what happened. I don't know why the police report says XXX. Everybody was in a heightened state, what have you. Okay? So you gotta try to remedy that early on.
If we have a case where our client is alleging that the husband abused her but also abused like her two daughters, do we include that in this case, or do we keep all of that information about the daughters separate?
You could put that in this case.
Okay.
You could put it in here as part of the, it's like a pattern of abuse that he was doing, yeah. Okay. Any questions on the extreme cruelty? Proving good moral character, this just basically means you need to get a certificate of conduct where your client lived 6 months or more in the last 3 years. Okay? So if your client lived in New York City the last 3 years, you only have to get one from New York City. However, in the last 3 years, your client moved from here to there to there to there, but she didn't live anywhere more than 6 months, then you don't have to get anything. Okay? But if she lives somewhere more than 6 months, you do need to get a certificate of conduct from that country. I think there's a case one of you guys have where the client came from home country just recently, like last year. So we definitely need the contact certificate from that home country, and I think the client got it already. But if she didn't, we have ways of getting that. Again, you talk to the consulate, you try to get all kinds of things, and some countries are easier to get those than others. Some countries are almost impossible to get those, and it just takes a lot of time and effort. But if your client needs one from outside of NYC, New York, just let me know, and we'll talk about how to get that. Okay, this is, and the bad spouse waiver cases, you do not need a good conduct certificate. So just so you know. And the thing with NYPD conduct certificates, they expire within 6 months. So we advise everybody to tell your clients to get this towards the end of your filing, like right about the time you're going to file, because it does expire within 6 months, and then your client will have to go back if it has expired. So just make sure of that. Okay.
Wait, you were saying in the battered spouse waiver case, you don't need to obtain this?
Yeah, you don't need a good conduct certificate in a battered spouse waiver case. They don't require it. Yeah, I don't know why, but they don't. It was just a good thing. And yes, I will get into that in a minute. That's the second part of this training. Standard of proof is any credible evidence. And you can look at INA section 216C4. Okay. If you want more. Okay. We're going to go a little bit more. Yes?
There's no other rules as far as evidence?
No.
You let everything, okay.
Immigration courts like that too. There's no standard rules of evidence. So we're going to go. Sergei and Victoria were married in a religious ceremony in Brooklyn, New York in 2011. They were civilly married at the Ukrainian consulate in New York City in 2014. Sergei controlled all the finances, and everything was in his name only. They do not have joint bank accounts or joint bills. Sergei did not include Victoria in his tax filings either. They had a child in 2012. So, what would you say is her evidence for all those elements we talked about? What about her good faith marriage? I mean, not a good faith marriage. What about her legal valid marriage? Which date is it? 14 or 11? 2011 or 2014? 14. Religious marriages only are not recognized in New York State. You need to have that civil marriage, okay? So if your client says, oh, I was married religiously here and never got a civil marriage, then she cannot file because there is no valid legal marriage, yes.
Does the abuse have to have occurred during the marriage, or like could they have been abused before they got married?
So some of the abuse could have happened before marriage, and then after marriage, something has had to have happened after the marriage too. Yeah. Okay, and then what about joint residence? How is she going to prove the joint residence? I think somebody said earlier, maybe.
I said maybe going to school, but at that time I didn't know that she had a child in 2012, so maybe on the birth certificate.
Maybe on the birth certificate there's I don't remember if there's an address on the birth certificate for the parent, but maybe.
Medical bills?
Medical bills, things like that, right? Get anything and everything that you can in terms of trying to prove that. Okay. And then you have the child, right? They have a child together. So that in and of itself is 90% of the way there for good faith marriage, according to folks up in Vermont and Nebraska. For some reason, if you have a kid, it's open ticket. So again, preparing the self-petitioner's affidavit. Like I said, it is key to your filing. This affidavit is going to be key. Organize this chronologically from the time she met him, and then in this affidavit, you're going to address all of the required elements. And then also address unavailability of some. I don't have this because X. You're going to be writing this for her after interviewing her, while interviewing her. So you're going to be doing the writing. We have sample affidavits in the manual. So look at the manual, look at the samples, and they're pretty, comprehensive. And again, it has to be consistent with all other evidence submitted. And if there is some kind of inconsistency, you need to address that inconsistency, why it's inconsistent. And because if you submit too many things that are inconsistent, it shoots down your client's credibility. So you definitely want to be inconsistent. If something's inconsistent, address it, say why, and how you're going to remedy that. Any questions on that? Same with the affidavits of supporting affiants. You're going to talk to your client and say, hey, do you want, can I talk to your friends? And then you're going to call them and say, okay, can we have, a conversation about this person, et cetera, et cetera. But make sure your client calls them and lets them know. A lot of times, if they don't have joint residence documents, like maybe they're friendly with their neighbors or their landlord, and the landlord or neighbors can, write an affidavit. It can be very short, like I know this person to have lived here I'm her neighbor, and that's it. You just need a few lines if necessary. Okay.
Do we ever do on-site investigations, or is that something we can contact you guys?
You wouldn't do on-site investigations. But if you wanted to, you could contact me, but we don't do that, yeah. Yeah. Mm-hmm.
Do you have document translation services?
We don't have document translation services. Akin does. Yeah. So anything and everything that is in a foreign language, a good point, needs to be translated into English. Okay. Any questions? We're going to take a short break. I know we're overdue for the break, so 5 minutes. We have a lot to cover, but come back and we'll keep going.
sorry?
How are your assignments going?
Oh, they're going good. I picked up a new one today.
I'm so
Yeah. So I had an instance where I missed something where I wasn't fast enough in replying. So I hit reply all and
Well, I mean, it would have been good to do that because then people know not to respond after.
yeah, but it was weird. Thankfully, I didn't write anything doing that. It's like, yeah, I would like to do it. But it's nice. It's good. I'm on a corporate assignment. It's nice. It's complicated corporate structure.
So are you doing governance officer?
No. So the corporation and bankruptcy.
Oh, I see. Like a restructuring.
It's not exactly restructuring, but the corporate department of handling this. It's a renegotiation of the lending agreements. It's so different from litigation.
Are you on the litigation side? Oh yeah?
So I have 2 assignments and then I have to VAWA them. And I'm on a busy for
Yeah, I have 2 assignments too.
What do you do?
Funds assignment. We're launching a startup fund, which is pretty cool because I'm like really getting to see like a lot of the main documents that you would draft to launch a fund. The only thing is like there's a lot of guidelines. So like there's terms that we have to like ease up on. And then there's like the parties involved. So like the fund is in the UK, it's incorporated in the Cayman. We have like an administrative program. So it's like all of these, and then we're getting message from the, so all of these parties have to talk. We have to get all different laws of different countries right. So it's very interesting. Now I read through the first document that comes over it's very interesting.
So what do you have to do?
Okay. We're back. I hope you guys got your coffee, caffeine, food, bathroom, everything. So, okay, so then there are other events, things that happen in our clients' lives. They're not just all about them. There's things, children, divorce, death, remarriage, people's lives go on after they file this or while they're filing this. So what does all this mean? Children of VAWA self-petitioners, they are derivative beneficiaries. Children in immigration land are people who are unmarried and under 21 at time of filing. Okay, so it's not 18, it's 21, under 21 and unmarried. And children must remain unmarried and until after adjustment of status of the child. Okay, so the child, they may age out because you can't stop age from happening, and they might become 21 and over, but they're still considered a child beneficiary, even if they turn 21. However, if they get married, they will then be out of child category. So the child has to stay unmarried until they actually get their green card to stay a child. Doesn't matter if they're 25, they're still considered the child, but if they get married, they are no longer a child. If they are 18 and married, they are no longer a child. It has to be an unmarried person under the age of 21 when the petition is filed. All the children will be listed automatically on the 360 form, and they will be considered derivative children if they are not U.S. citizens or lawful permanent residents already. So you don't have to do a separate application to make them a derivative child. They just get listed on that 360. Just make sure that you list each and every one of her children, even if they're older, even if they're out of the country. Just make sure that you do list each and every one of her children. because you're dealing with children, there are some ethical or family members that may be derivative applicants. Ethical considerations to have. There's dual or multiple representation of principal and derivative beneficiary. You have duties that are owed to both principal and derivatives. There's the duty of loyalty and duty of confidentiality. Remember this in law school, right? Professional ethics or professional responsibility class. So you have the duty of loyalty, duty of confidentiality, especially with children, parents, there might be sometimes conflicts of interest arise. If you have teenage children that are in home country or they're here, whatever happens, there might be a lot of issues. The most issues that we see with derivative parent-child relationship that happens is because it's a teenage parent kind of rift. And if that happens, remember that your principal client is the principal client and not the derivative child. And this should also be in the engagement letter and retainer. All of your firms, you're going to use your firm's engagement letter and retainer, so just make sure that that language is in there about the maybe the conflict of interest that may arise if there are derivative children. The impact of divorce and remarriage. Clients, once their lives go on and they want to get divorced, they want to move on with their life. If the self-petition is pending, a divorce will have no impact. Okay, that's okay. You can file this and then get divorced. There's no impact. Okay. If before the self-petition is filed, say that she gets divorced right before you guys file it, you have 2 years from the date of the final judgment of divorce to file this. The VAWA is, you cannot file a VAWA self-petition if it's been more than 2 years from the final judgment of divorce from that relationship. One thing to remember about divorce, the divorce grounds are irrelevant. It does not matter that she filed on cruelty. It does not matter that she filed on irretrievable breakdown of the marriage. It does not matter that she filed on whatever grounds it is. He might be imprisoned or she might have filed on abandonment grounds. Doesn't matter what grounds those are. The only one that does matter is if he files for divorce against her and he files on the grounds of cruelty, saying that she was cruel against him, because that kind of counteracts what she's saying about him at this point. Yes?
So if she received initially a conditional green card,
yeah,
it's not pending on that.
So that we're going to talk about. That is where the conditional green card is where we talk about the battered spouse waiver. Okay. Yeah. So we'll talk about that. If she got a conditional, the question was if she got a conditional green card, does the divorce make any difference? And we'll talk about that in a bit. Okay. So that's the divorce, but remarriage of the self-petitioner. A lot of clients say, hey, you know what? I found another guy. I want to get remarried. What do you tell them? If the self-petition is pending and they get remarried, it is invalidated. So no, you should tell them, hey, are you sure that this guy is going to be a good guy and he's going to actually file for you and all of this? Because once she gets remarried, the one that she has filed is invalidated. It's no longer valid and they will deny it. Okay? So you have to make sure she understands what that means. Like, she's going to get remarried. That means all the work she's done with you guys is valid. If she remarries after the self-petition is approved, if the 360 is approved, then it's okay. Not a problem. Okay? So she can wait. Right now, the waiting period is about a year from the time you file. A year and change. Okay. And then what happens if your abusive spouse loses their immigration status? They were a lawful permanent resident and then they get deported, or he dies. Loss of abuser's immigration status, it is okay to file for up to 2 years if loss was related to domestic violence. Okay, say that domestic violence is a crime that you can be deported for, that you can actually lose your green card status for, your immigration status under, because it is a crime enough violations of it, they can prosecute you, and then you can lose your green card status. So if that loss was because of the domestic violence, because of these criminal activities that was surrounding the domestic violence, then you can file up to 2 years. If that loss for some other reason, that your husband, say that my husband was a drug dealer, and because of that he gets deported because of drug related offenses, then that loss makes it so that I cannot file. Okay. If my husband dies, death of a U.S. citizen abuser, it is okay within 2 years of the death. Now, the death of a lawful permanent resident abuser, you're not eligible. It's kind of, I don't know why, but it's not fair, but that's what happens. Again, giving priority to U.S. citizens is basically what this is doing. Okay, I'm going to skip over this slide. And we're going to move on because there's a lot to go on, and I think you guys have been absorbing. So, okay, so what are you going to file in this self-petition? This is the nuts and bolts, nitty-gritty details of it. You're going to file a cover letter. Again, all of these things I'm talking about right now, there are samples in your manual. Okay, the latter half of your manual are all samples. We have multiple different kinds of samples for different kinds of scenarios. So please look at your manual. You're going to file a cover letter. You're going to have a Form G28, notice of appearance as an attorney or representative. If you're working with a partner, you're working with a senior associate, that person goes on, your name could go into the G28 as well as an associated person. And there's all this, there's space within that G28 for you to put your name in as well. You're going to file the Form I-360. And then there's going to be an index of exhibits, and then all of the exhibits starting with the affidavit from your client. All forms are found at uscis.gov. USCIS changes form additions constantly, and they don't always tell you that some form additions will be accepted and others will not until you actually file it, and they kick it back and say, oh, this form addition is not what we're accepting right now, please refile. So please just get the newest, most latest form from uscis.gov. So what happens after filing the I-360? You'll get a receipt notice. You'll get a notice of approval or denial, for sure. Those two things you'll absolutely get. Receipt notice usually comes within about a month of filing. If you do not get your receipt notice within a month of filing, let me know, let Amanda know, and we will talk to you about how to contact them and ask them to give you a receipt notice. Notice of approval or denial, again, it will come within about a year and change with the approval. What you might get, notice of prima facie determination. Prima facie determination basically means USCIS received your application, they looked at it, and for the most part, they think it looks good on its face. You've kind of hit all of the elements. So therefore, they'll give you a notice of prima facie determination. With that prima facie determination, your client can access some public benefits, some cash assistance, Medicaid, emergency Medicaid, okay? And then you may get something called a request for evidence. I talked about this a little bit earlier. Request for evidence means that they've looked, now at this point, they're looking at your application more thoroughly, and they're thinking, oh, there's some piece of it lacking. Therefore, they're gonna send you a notice saying, hey, we don't think you've proven this element thoroughly. So please, you've said this, 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 however, this, so give us more information on that. You may get something else after you send an RFE of a notice of intent to deny. This is the beauty of immigration sometimes, and there's slowness actually, but it's still good. You get 2 or 3 bites at the apple. They will let you go and try to remedy before they actually give you an absolute denial. So they may give you a notice of intent to deny saying, hey, you sent the RFE, however, we still don't think you have enough. We're still going to deny this. Or we're going to deny this. And then you have another chance to respond to that NOID. Okay, so again, when you do... Yeah. Oh, what they're going to deny you for? Yes. So they're supposed to, and if they don't, then you can always appeal that. So responding to an RFE or a NOID, when you get one of these, please call us immediately. You have for a NOID, there's a definite due date for both of these, an RFE or a NOID, and you need to respond within that time frame. So call us, the RFE can be very simple. Like it could be lack of translation. Hey, guess what? You didn't sign this. Or hey, we need a translation for this birth certificate. It could be that simple. It could be that easy. Otherwise, it could be evidence of good faith marriage, evidence of joint residence, evidence of this, that, or the other. So just be aware. Sometimes you've already sent in the record. You've already sent in everything you have, and they were sloppy in their looking at it. And it's more of a kind of like a snarky, not so snarky memo back to them saying, we fulfilled all these elements, this is what we did, here's this, here's this, here's this, look back in your records, please, here's this, here's this, here's this, and it's in the record, but as a courtesy, we're gonna give you back everything we already sent you, okay? So it could be that too. Yes?
If we have a notice of prima facie determination, like if we have a client that has a health issue and we don't want to wait the full year and change, can we sort of try and move it along because our client needs access to public health benefits?
So she can get public health benefits with a prima facie determination, actually.
But can we like rush that?
You could try to ask for expedited processing for humanitarian reasons. Expedited processing sometimes works. I have yet to get them to do it for me. It's really hard, and you have to have serious exigent circumstances of why this needs to be processed like now. Like somebody is dying and you really need this, you know, that kind of thing. But again, since they can get emergency Medicaid and they can get medical services, so it's hard. But again, you can ask for expedited processing, but they have this whole huge criteria of what they will consider to be expedite worthy. Yes?
If the person has one of those temporary green card situations and they're going to, you know, it expires before the 1 year period where you get notice of approval or denial, what happens?
Oh, we'll talk about that in a minute too. Hang on, we'll get there, I promise we'll get there. So, and then you may get a notice of denial, which is rare, but it happens. And if you have a notice of denial, please call us immediately to determine best approach. You have 33 days to appeal from date of denial notice. It is not the mailbox rule. Mailbox rule does not apply. It means that they have to have received it on the 33rd day. It has to be received with USCIS, okay? It's not that you mail it out on the 33rd day. It has to be received by them. And again, it's from the date of their notice. So mail delays, all kinds of stuff happens, and then all of a sudden you have 5 days to respond. I've had that happen, and it's not pleasant, but you can respond in some fashion, at least. Again, follow steps in the manual, use it, discuss case. If you guys get stuck on something, call me, email me, leave me a message if I don't answer. If you email me and I don't respond within 2 days, please email me again. Usually I will respond and say, oh, I'll get to this by this date. Thanks. You know, I'll acknowledge your email, and if I don't acknowledge your email, please nudge me. Like, if I don't acknowledge your email in like 2 days, get back to me, okay? It's not that I am ignoring you, it's probably because it just fell through the cracks somewhere. If you get an approval, what does it do? You're eligible to adjust status to lawful permanent resident. We're going to talk about that in a minute. You will also get deferred action status, which gives you some benefits to some public benefits. Deferred action also gives you, in this strange political times that we're in, it will at least give you one barrier to getting deported immediately, okay? There's something they're saying, okay, you know what, USCIS knows I'm here, US government knows I'm here, they're not gonna deport me. They get it, you know, I have some kind of colorable defense here. You could get employment authorization, and these benefits also extend to the derivatives. So, the 360, you've applied for it, now what happens? You can, and if it gets approved, you can do something called the adjustment of status, okay? Adjustment of status is change of immigration status to lawful permanent resident. That's why it's called an adjustment of status. You're adjusting from a non-immigrant to an immigrant. This is filed on Form 485 for each individual applicant. If you have derivative children that were on the 360, they need their own separate 485s. At this stage, everybody needs their own application. At the 360 stage, only the principal mom needed it, and the derivative children fell under there. At this stage, everybody needs their own 485 application. And then this is not reviewed and adjudicated at the Vermont Service Center. This is actually reviewed and adjudicated at the local district office here in New York City, which is located at 26 Federal Plaza. And this is based on principal's marriage to a U.S. citizen or lawful permanent resident. Okay? If your client's husband or spouse is a U.S. citizen, the 485 application can be filed concurrently with the I-360 application. Okay?
But not if they're a green card holder.
Yeah, if the spouse is a green card holder, only the I-360 can be filed at this time. Okay, only the sub-petition can be filed at this time. Once the sub-petition is approved, then you have to wait until that priority date becomes current. Priority dates are, I was just at a conference where it was fascinating to learn that there's a team of people that decide what the priority dates are, depending on how many people from what country has come into this country on a immigrant visa. Because there's caps, there's statutory limitations and caps on how many foreigners they're allowing to become immigrants. And so people are waiting. There's this big long wait list, and it's if you look at, it's called the Visa Bulletin, and you can see where people's priority dates are. It's like from the filing date, that's when their priority date is, and then that has to become current for them to actually file for their green card if their spouse is not if they're not an immediate relative of a U.S. citizen. Yes.
So those rules about the death of the spouse, and suppose the VAWA is granted and then the spouse dies, they were LPR.
No.
What would happen?
The VAWA was granted and they were an LPR?
360 is granted.
If the person dies after the 360 is granted, it's okay. If the person dies during the pendency of the 360, then
right.
Yeah.
So that's what you were saying, right? So I was just wondering what happens if the person dies after the 360 is approved, but before the 40.
That's fine. That's okay. As long as you have an approved 360, then you can file for that the 485 as when your priority date becomes current. If you're not an immediate relative. Immediate relatives are parents, children under the age of 21, married children under the age of 21, and spouses. That's what they consider immediate relatives of U.S. citizens. Okay. So all of your cases, I don't know if you've gotten your case files yet, but in them we have case opening reports, and in the case opening report it will say your client's spouse is a U.S. citizen, therefore you can file concurrently, or your client's spouse is not a U.S. citizen, so you can only file this at this time. So we've already done the analysis for you, but if you have any questions, again, give us a call. So you have to be eligible to adjust status. You have to have an approved I-360 sub-petition and a U.S. citizen spouse, or immigrant visa is available because your priority date is current. And the last part is you cannot be inadmissible. Okay? Inadmissibility is for grounds of inadmissibility. What does this mean? It means people the U.S. government deems to be undesirable. INA Section 212A, Immigration Nationality Act Section 212A has a full list and lists every single inadmissibility ground. If you want to peruse it at your own convenience, please do so. We're going to talk a little bit about the more common grounds here. Health-related grounds, meaning you have some kind of disease that the U.S. deems as a health hazard to everybody here, and that is found on the CDC list. But again, the way we deal with the health-related ground is you have to get a medical clearance, and the medical clearance, the doctor will say yes or no on this. Some health-related ground that may not come in the medical clearance, again, that may show up in what you're writing in your affidavit is suicide. Okay, suicide may be deemed a health-related ground because it's a condition that may make you harm yourself or others. And if your client had suicidal ideation, and if she talks about it a lot in her affidavit or in her story, then they might say, oh, well, we need a clearance from a mental health professional saying that she is no longer suicidal. If she really actually did try to commit suicide and you have medical records about this, you have to talk about it and explain what happened there. A lot of our clients say, yeah, I wanted to kill myself, okay? you need to see, there's a line between I want to kill myself because the abuse was so bad, and then to actually taking steps to doing that. Okay, so if she says, I actually went to the bathroom and drank a cup full of Clorox, whatever it is, that's a problem, okay? We're gonna have to address that issue because, again, it becomes an inadmissibility ground when she has to adjust status. Okay, fraud or criminal-related grounds. Some of our clients have been arrested. It may or may not be an inadmissibility ground, depending on the length, the kind of crime it was, the length of time they would have spent in jail, etc. So we'll do that analysis with you. Fraud or misrepresentation to gain an immigration benefit. This is lying to immigration officials. What kind of lie did you make? Okay, unlawful presence. But unlawful presence is only triggered when you leave the country. So you could have been here on a valid visa for 10 years, 20 years. I mean, not a valid visa. You could have come in on a valid visa. Your valid visa, your time of stay was 6 months, and you continue to stay 20 years, and you're now no longer actually, you're now an undocumented person. That's okay. You can stay undocumented. But once you leave the United States, then you can't come back in. Inadmissibility grounds trigger once you leave. So it's like the leaving part that will be the problem, not the staying part. But if your client has inadmissibility grounds, the obvious ones that we know of when they talk to us in the beginning, we will have flagged them for you. If in the course of your representation of your client, you are talking to them and they're telling you things and you're thinking, oh, this was never mentioned, I think this might be an issue, please call us. We'll go through that analysis with you and talk to you about what needs to be done. Because if there are inadmissibility grounds, there are arguments to be made about them. The ground does not apply. No, she was not suicidal. No, it's not really suicide. She was not a harm to herself. Or there is an exception, right? That there is an exception. There's a VAWA specific and or general exceptions all over the INA. So make sure that you do talk to us about that. If the ground applies, you can waive this ground on Form I-601 for various reasons. And again, they give a lot of leeway to VAWA self-petitioners, people who are filing for adjustment under the Violence Against Women Act, because they know that there are some circumstances they just can't control. Okay? So then if no waivers are available, absolutely there's no way that we can get around certain things, then other remedies might be available, like a U non-immigrant status case. Okay, filing a U non-immigrant status. Again, if that happens, we will have flagged it. We will talk to you guys about that. The one absolute no-no, cannot ever waive it, is false claim to U.S. citizenship. Cannot be waived under the VAWA statute, under doing a self-petition. However, false claim to U.S. citizenship can be waived under a U non-immigrant status case. So if there are certain cannot be waived at all, we will talk to you about switching the case up to a U non-immigrant status instead. Okay. If you do have to file a waiver, what are you going to file? Again, it's the form, your G28. There's a payment of fees, or you're going to ask for a fee waiver. The form I-601, and there's an index of exhibits. Okay. There we go. Again, travel risks for adjustment of status applicants. Like I said, the risk is once you leave the country. If you had been here undocumented for many years, the risk happens when you leave. So we tell clients, please do not leave. Okay? As much as possible, please do not leave. However, if you really, really need to leave, you can get advance permission to leave, called advance parole. And I've just recently actually helped a Akin team to do this. And you get advance parole to leave, you get the permission, and then you come back. Okay? So if at all possible, that's what you need to do. Yes?
What is the timeline for that advance?
Parole?
Yeah.
So the timeline for advance parole takes 3 to 6 months. However, if it's emergency, somebody is sick and dying in home country, in New York City, which is not the case for almost, I mean, a lot of the other jurisdictions in this country, you can actually ask for the local office for emergency advance parole, and they will give that to you, and they will permit that.
Is advance parole the same as I-131?
Yes, it's an I-131, and you get that. And so it allows you to go, gives you permission to leave and come back without any repercussions on your status. What do you file in the I-45 packet? You file your cover letter, your G-28, payment of fee or a fee waiver affidavit. The form I-45, there's a G-325A, which is a biographical information. Form I-864W, again, affidavit of support exemption. So all of these things we have samples of in your manual. I'm not going to read all of this stuff. And we have document assembly instructions. We have document checklists, so you kind of can check off what you have, what you don't have, what you think you might need to get. Medical exams, do not include the medical exam. Medical exam is necessary, but don't include it in the initial filing because medical exams expire within a month of having them done. And in the past, USCIS used to accept them and say, as long as it was filed within the year that it was done, it's fine. But now they're not accepting that. They're saying, oh, it was filed and then now it expired because they were sitting on it. Then your client has to go and pay another $250 to get the medical exam done again. So it's just, we don't include those at this time. We'll include them. USCIS asks you for it, and that's when you go get those done. And I think in our manuals, we have tried to take out all of those places where it says medical exam to be filed with. But if we didn't and there's some mistake, please disregard that you file the medical exam at the same time as your 485. And then that's the adjustment of status. And then work authorization. Your client can get work authorization. Nowadays, the 360 form has been changed. The 360 form has been changed so that you just check off a box and you don't have to file a separate employment authorization application. However, if you're concurrently filing for your client's husband is a United States citizen, so you're concurrently filing the 485, you can actually file you would actually file the employment authorization together because your client will get her employment authorization within 3 months then. Okay? So if concurrently filing the 485, a 765 employment authorization is also filed. And then this will allow her to the right to work lawfully. She'll get her social security number. She could get state and city IDs. And this, again, works as another form of ID for her. And these are the forms that you file in the I-765. Again, the form the application is the G-28, notice of appearance. You need a notice of appearance for every single one of these applications. And why we say this is because immigration, you'll put it all into separate packets, because they take things apart, and you don't want them to say, oh, well, we don't have a G-28 for this, but we have it for this. Like, don't assume that they're going to put everything together themselves. Make sure that you put it together for them so that it takes the least amount of time, if they were to take it apart, for them to like kind of piece it together. The employment authorization expires every year. So you need to renew this until she actually gets her green card, your client gets her green card. It expires every year, so file it within 120 days, 4 months before the expiration. It takes about 3 to 4 months for them to process it. This is why we say file it 120 days before the expiration. Because if you file it too late, what will happen is there's going to be a lapse in your client's employment authorization. So make sure that you file it 4 months before it expires. Okay, so the self-petition timeline for a concurrent filing, you should be able to meet with your client and file everything within 3 months. We have designed this program to be done so that you guys can do it during your summer program. Okay. A lot of, does that always happen? Not really. And that's because, clients have schedules, like it's just really hard to find clients, like they don't come or they have to switch around their schedules and things like this. So understandably, but it is possible to file within 3 months. We have a guidance and a timeline in your manuals. Actually, week 1, do this, week 2, do this, week 3, do this, okay? So follow that along and you can file within 3 months. After you file 2 to 3 weeks, we say 2 to 3 weeks after filing, you will get the receipt notice. However, these days it's been taking a little longer, so it may be more like 4 to 6 weeks after filing, you will get that receipt notice. If you do not get that receipt notice within about 6 weeks, that's a problem. Okay, so please let us know, and so we can ask USCIS for that receipt notice. Make sure that everything is filed with some kind of mailing that you can do, you can track. We like UPS and FedEx because you could track it, and there's always, and they're cheaper in terms of like next day delivery. US Postal Service, if you do next day delivery, tends to be a lot more expensive. So if you want to do next day delivery and track it, make sure, and if you're hitting up against a deadline, make sure you do next day delivery and get it there. Again, because it is not the mailbox rule, but actually received in hand rule for them. And then 1 to 2 months after filing, you will receive a prima facie determination. If you've concurrently filed, since you've concurrently filed with the 765, which is the employment authorization, you will get a employment authorization within 3 to 4 months of filing it. 6 months to a year after filing, there is a decision. The 6 months to a year, I'm lying about it because it's more like a year and change now. And their processing times are posted on USCIS.gov's website if you do want to go look at it. If you concurrently filed, once you get your I-360 approval, if you haven't gotten a RFE or anything else in between and answered all those questions, once you get the approval, then the 360 is no longer at Vermont Service Center. You got the approval, and then Vermont will transfer the case down to the New York District Office, okay? So you don't have to do anything more. They will give you a transfer notice. You'll get a couple of transfer notices between then. Okay. And then if it's a non-concurrent filing, this is a little bit different. Up until 6 months to a year after filing, or a year and change after filing, that is all the same. Okay, but you will not have filed the 485, and you will not have filed the 765 in a non-concurrent filing. So once the VAWA sub-petition is approved, you will then get the employment authorization. So for a non-concurrent filing, your client is probably going to get her work authorization in a year and change after you file. Okay. And then once that's approved, you will then wait for that priority date to become current, and then separately file that 485 adjustment of status application. Any questions?
What do you advise your client to do for work if they don't have the work authorization?
So what do you advise your client to do for work if they don't have work authorization? They will ask you, what am I supposed to do? This is your answer. You are not legally allowed to work without work authorization. You as an attorney cannot advise her to do otherwise, because doing otherwise, she's not legally authorized to work. So you're going to say that to her. And then she's going to say, well, can I work for cash under the table? And you're going to say, I cannot tell you that you can work for cash under the table because you are not authorized to work. And then she does what she needs to do. Okay? Most of our clients work without authorization. They have been working before they came to see you. They came to see us, They have to make ends meet. They will have to, they have to put food on the table, especially if their abusive spouse is not giving them any money, or if they're separated from this person. There is a specific question in the I-360 that asks you, have you ever worked without work authorization? And that answer is usually yes. And USCIS really doesn't care that much about that, because you have to say, I worked, and you're not going to say specifics, you're going to just say, I worked as a blah, blah, blah to make ends meet. But you don't say, I worked at such and such address for such and such person. You're just going to say, I worked as a housekeeper in Far Rockaway, Queens, to make ends meet. I earned X. If you want to even say I earned X, doesn't matter. Yes.
So, working without authorization, if we disclose that, it doesn't become a new grounds for inadmissibility that you need to address?
No. So the working without authorization does not become a new ground of inadmissibility that you need to address unless there was some fraud involved, okay? Because she received, because she said she was a lawful permanent resident on an I-9 form, because she has somebody's work card, or she has a social security card and she got a work authorization, or, you know, whatever. I mean, she has a social security card, maybe not a work authorization, but a social security card. And with that, she has to fill out that I-9 form. And then the I-9, she said, there's that part of the I-9 says, I am authorized to work in the United States because, 1, I am a U.S. citizen, or 2, I am a lawful permanent resident, or 3, something else. Okay, I don't know if there's a 3, but basically, if she fills out an I-9 form for work purposes, and in there she's misrepresenting herself in terms of her status, that becomes a misrepresentation for an immigration benefit. So then that becomes an inadmissibility ground. So working for cash under the table, not so much a problem. Working officially with somebody else's documents can become a problem if your client says, I bought a social security card and an employment authorization from someplace, I don't know, under the BQE someplace, and I'm using it, and she tells you this, call us. We'll talk to you about that whole strategy, what to do. We've been hearing some disturbing things coming out of from interviews recently about interviews, meaning adjustment of status interviews, where people are getting their green cards, where people are asking, well, did you work? Yes. How did you work? Oh, I used a fake social and a fake employment authorization. How'd you get it? I paid for it, or I bought it, or I stole it, whatever. And it's like, oh, then you just now committed, you admitted to committing a crime involving moral turpitude, identity theft. And then it becomes another issue that you have to waive, okay? We've been hearing these weird things. I have yet to experience that in New York, okay? This is in, that case I think I just said was like in Minnesota or somewhere in the Midwest, and then another one out in Oregon. Somebody else was telling us about this today. I mean, just recently. So just, if this happens, please let us know, and we will talk to you guys about that, okay? Okay, so any questions on a self-petition? It's a lot of information. Okay, now we're moving on to the VAWA spouse waiver. I know a lot of people have been asking about this, and we've been talking. I said I'll tell you in a minute. I'll tell you in a minute. VAWA spouse waivers. Why is it a VAWA spouse waiver, or why is it a waiver, hardship waiver? So again, you get family petition obtaining permanent residence. You have your family do a joint petition to remove conditions on residence based on ongoing marriage, signed by both, filed 90 days prior to expiration. Okay? That is if you are going to file with your husband. You've already gotten your green card. You have a conditional residency, though. Why is it conditional? Because the marriage is less than 2 years old when the I-130 was approved and the 485 is approved when you're filing. If your marriage is more than 2 years old, then this will not happen. You will get a 10-year green card. But this, again, goes back to the marriage fraud issues. This is why USCIS did this. They decided, hey, you know, if you're going to file like immediately after you get married, there's some question of the validity of this marriage. So let's make sure that we only give somebody a conditional residency. It's good for 2 years. And at the end of the 2 years, you need to file together or do a waiver. So, I'm sorry, I can't see very well. Okay, so if you do it through the families, you file a joint petition to remove conditions on residence based on your ongoing marriage, and it's signed by both parties, and it's filed 90 days before. Okay? We're still in a good relationship. This is what I'm proving to you. We're in a good relationship. We're going to sign this together. If you do it under the VAWA Act, so it's called a hardship waiver. It's based on good faith marriage and physical abuse or extreme cruelty during marriage, okay? Or hardship waiver that's based on good faith marriage and divorce, or extreme hardship to the person if they were to be, they were not to get the conditions removed. Okay. So that's why we filed this. Okay. Yeah, the third column is other reasons why you can file a waiver of the petition. It's because there was a good faith marriage and there was divorce. Maybe there was no abuse, but it was a good faith marriage and divorce. Or there's extreme hardship and why you can't file together, and being not getting your permanent residency would pose an extreme hardship for a U.S. citizen child or for yourself. It can be.
Is it possible to simultaneously file under VAWA and other by any chance?
Yes, you could do both. You could do both. You could do both. So it's filed under on Form I-751, and you could check off both boxes here. Okay, it does say my conditional residence is based on my marriage to my spouse, but I'm filing this under, and you can actually check off 2 boxes. Okay. In the past, they used to say check off only 1 box, but now you can check off both boxes. It's fine. Okay. Again, there's no good moral character requirement here. So it's just under this, and most of the proof is going to be about the same. The one thing that's different here is derivatives of conditional residence. Remember in the 360, the self-petition part, I said derivatives, you don't really have to do anything except for list them, and they're all included, and you don't have to, there's no other thing to do. There will always just be the derivative, and USCIS will take care of them as derivatives. In the 751 context, that's not the case. Okay? Because what it is the 751, somebody already has a green card. They have a conditional green card. So if the derivative child also received a conditional green card within 90 days of mom receiving it, they can be included in the filing. If the child received a green card after 90 days of mom receiving it, the child has to file their own. If the child never received it, okay, the abusive spouse didn't sponsor child, only sponsored mom, then the child just has to wait until mom's conditional resident, and then mom can file for child on her own as a child of a lawful permanent resident. Does that make sense? Okay. So there's many ways that derivative children can be impacted in a 751 case. Yes.
And if the child's already a citizen,
The child's already a citizen, not a problem. Okay. And if the child is a citizen, again, if the child is 21 and over, the child could probably apply for mom as well. Okay, so the other good thing about the waiver is that there's a 90-day rule that you have to file a joint petition 90 days before the expiration. However, with a waiver petition, there is no rule. There is no time frame that you have to file this in. Obviously, if you file it as close to the time that the conditional residence expires, the better it is. But there's no rule that says you have to file it 90 days before, or you have to file after. You could file it a year before it expires, which is fine. Okay, so that's one good thing. The other thing is, I think you asked, right? What happens if can we ask for expedite if the thing's going to expire? Well, you don't have to ask for expedite because the receipt notice for 751 extends the conditional residency for another year. So what do you file? You file the cover letter, you file the Form G28, payment of fees. There is a fee for this. The 360 does not have a fee. The 751 does have a fee. You do the index of exhibits. Again, what are the elements? It is good faith marriage. Same thing. Good faith marriage, joint residence, and abuse. 3 things. Only. Those are the elements. But it's going to be the same standard of proof. That's going to be the same kind of things that you're going to be looking at, same kind of analysis that you're going to be doing that we discussed in the VAWA self-petition case. So again, exhibits are very similar to the I-360 application regarding the proof of good faith marriage and proof of abuse and battery. Any questions so far? Okay. So what happens after you file? Again, you get that receipt notice extending conditional residence. And that with that receipt notice, your client can travel. It gives her another year of lawful permanent residency. And then you'll probably get a notice of approval or denial. This also is taking about a year and change for them to give. In the meantime, you might get an RFE, just like we talked about earlier. You might get annoyed, or you might be called in for an interview. The I-360 piece earlier, the VAWA piece, is adjudicated on paper, and immigration, Vermont Service Center or Nebraska Service Center only looks at it. The local office only looks at the adjustment of status piece of whether you are inadmissible or not. In an I-751 case, that's not the case. What happens is, if Vermont or Nebraska or whichever service center is looking at it thinks, oh, we're not really sure, we sent an RFE, okay, well, we're not really sure, we're going to send it in for an interview. So you have another chance, one more time, at the interview here. But in an I-751 interview, everything is a free-for-all. They are able to ask about the good faith marriage, the underlying elements of the good faith marriage, the underlying elements about the abuse. And then they will approve or not approve the waiver petition. In an I-360 485 case, when you go to that 485 interview, immigration officers here at 26 Federal Plaza are not supposed to look at that underlying 360 VAWA because it was already approved by Vermont Service Center. So they don't get to go back in and dig and say, oh, well, what about this or that, the other, to your client, unless it has to do something with her inadmissibility, okay? But in a I-751 case, if it does get referred for interview, then they can have, they kind of can ask a lot of things. Okay. The timeline on this, again, like I said, you could file these also in about 3 months. Okay, these can all be done in 3 months. You file it 2 to 3 weeks after filing. It's more like, again, like I said, 4 to 6 weeks after filing, you will get that receipt notice extending her status. Once your client has that receipt notice extending her status, she can travel. She can also go and get a stamp in her passport that shows that she has a temporary green card. Okay, it's called an I-551 stamp, and that shows that she's got temporary green card status, like lawful permanent resident status. And so if she wants to travel and she thinks, oh, just this piece of paper isn't going to do it, and she's a little worried, you can get that stamp, and then she can leave the country. 1 to 2 months, 2 months after filing, you'll get a biometrics notice. You will also get a biometrics notice on the 360 applications as well for employment authorization and for the adjustment of status. Biometrics is a fancy word for fingerprints and picture. Okay, you go to an application service center and they take it. It's an immigration, office, and they'll do that. Okay. And again, you might get a request for evidence or annoyed or a decision, and the decision will come within about a year. Okay. Any questions on the battered spouse waiver? No. Okay. Best practices, communicating with USCIS. You can check the current processing times online. You should, once you get your receipt notice, you should sign up for case updates. You can do this online after you get that EAC receipt notice. You'll put it in, and we recommend everybody to do this because anytime there is any kind of movement on your case, you will get an email update saying that some kind of notice has been sent to you. And if you don't receive it within 3 weeks of getting this notice, I mean, there's something obviously wrong with the mail and you didn't get it, but at least that they sent something. So then you can say, hey, look, we got this, however, we never received it, what's wrong? And especially in New York City, the mail gets lost a lot. There's a lot of buildings here, a lot of buildings with multiple tenants, with law offices, and like there's a few buildings downtown that have like 5 or 10 different law firms in one office, so it can get lost. So you definitely want to keep track of things, and the best way to do this is actually to go and sign up for case updates on your case by putting that EAC number, which is the receipt number. Send all applications to USCIS through trackable mail, like I said, either FedEx, UPS, US Postal, which is the, with the return receipt and confirmation. However, we've had issues with that being timely, so again, unless you have a ton of time, I would recommend not using US Postal Service. The other thing is alert your mailroom of expected mail from USCIS. So you get this email and you go, so you know that something's supposed to be coming. So you talk to your mailroom people and say, hey, look, if anything from USCIS comes to this person, because not everything's going to be addressed to you. Things will be addressed to your client, and it will be, Mary Chavez at Akin Gump, and there's no Mary Chavez that works here, and then they're going to be looking for her, and then they're going to send it back. And we've had this happen multiple times where the mailroom, there wasn't communication, so the mailroom tried to find whoever this was, and they couldn't find that person in the roster of attorneys working at the firm, and so they said, nobody's here, sent it back twice. So just be aware of those kinds of issues as well. When you communicate with USCIS, because there's certain things that happen, you might want to know what happened to this receipt notice. You want to know something specifically, the case is outside of processing times, and you want to ask them about it. There is an email address, hotline follow-up, i360.vsc@dhs.gov. When you email them, you can make sure you put a copy of a G28, your client's name and A number and receipt number of the petition, if you have it, and talk to them about what the issue is. Most people will talk to us first, and we'll talk to you guys about what to ask them, why to ask them, if it's necessary to actually call them, okay, or email them or contact them. You can also call them at this number. And if you call them at the number, don't email them. They ask, do one or the other, but don't do both, because there is one physical file for your client. So if the person answering the phone grabs the file and you email, the person who is trying to answer the email can't find the file. So they ask, do one or the other, but not both. Email, there's an automatic response saying, we will get to you in 3 days. I think the same with the, it's either 3 weeks or a couple weeks, and then I think the phone is a voicemail system. You just leave your name and number and everything, and they call you back within 2 or 3 days. We recommend doing it via email, because doing it via email, there is a paper trail. You have email exchanges, you have proof that you've emailed this person on this day, if you have to escalate it further up, okay? The other thing is, do not call this last number here, call USCIS National Customer Service. Okay, if you have a G28 on file, you shouldn't call this number. You should just call directly to the Vermont Service Center, attorney numbers, or email the attorney hotline. Because when you call this number, they're not always USCIS officers. They're contracted a lot of times. Usually, mainly the people picking up the phone are going to be contracted people. They might read you what they see on their computer, which you probably can see too. And then if you say it's a VAWA case, they won't really talk to you anymore because of this confidentiality things. The statute standards, so they won't talk to you anymore. They'll say, oh, I have to get you to my supervisor, and that you'll be on the phone for half the day, basically, if you call this number. So I would say, don't call. I mean, they did try to make it better because you could leave your number and they will call you back when your time in the queue comes up. Before they were like, oh, your wait time is over 59 minutes, and you're just like, what? And then now they have this, they will call you back when your time in the queue. But again, that number, I would say, don't use it if at all possible. Okay. And then communicating with us, send us your drafts, all of your drafts. Please, please, please send me drafts as you start working on them. They will not be perfect. It's okay. Just start sending them to me. I will review. I will get back to you. Again, give me about 3 days to turn it around, but if I don't respond, even within a day, to say, thank you, I got this, email back. Okay, that goes for all of us, actually. If I'm your mentor, or if Amanda's your mentor, or if Susanna or Tim is, okay? So you're going to expect rounds of revisions. It's not going to be perfect the first time, the second time, and the third time. Sometimes it takes about 5 or 6 revisions. So just expect that. It's okay. It's not because you're a bad attorney or a bad writer or whatever it is. It's just like some pieces of information might be missing, and we're just looking to piece it all together. And usually the affidavits tend to be about, I would say, 8 pages. It's like a pretty thorough affidavit. If you're missing some details, I'll be like, we need more detail. Can you ask her about this? Can you say it in this way? I'll give you suggestions on how to frame it better, or in the best light possible, if it's necessary. Okay. At the end, you're going to send me a PDF of the filing, like all the signed stuff. So we have a copy of it in our file, just in case you get an RFE or a NOID or something, so I can just go back and say, oh, okay, this is what you filed, this is what you're going to give them. Okay, for our records, for your records. Communicating with us, again, call us with any questions. After you review your case, after you look at the manual, if you have any questions at all during this process, give us a call. And then you can immediately contact me if you get an RFE or a NOID, or if there's a case outside processing times, or if anything comes up with your client, just give us a call. And because immigration is taking so long to adjudicate these things, what we are advising everybody to do is please keep in touch with your clients. After you file it, don't wait till she calls you, but just call her every 3 months to say, hey, look, anything changed? Did you move? And it's status quo. And then if you're leaving the firm, please let us know. At the end of the summer associates will be handing off you'll do like a closing thing and let me know that you're leaving, and then who your partner is that's taking over, who the senior associate is that is taking over on the case. For Akin attorneys, I come back in the summer, in the middle of the summer, like sometime in July. And we could talk about issues that have come up, things that need to be fleshed out a little bit more, and that I'll talk to Rachel and the folks here to schedule that. So just be on the lookout for that. And at that time, you can bring, if you want, you could bring affidavits or just any kind of questions that have come up. And then, again, communicating with your client. Be flexible in scheduling meetings. Some of our clients have children. Lots of them have children. They can, and especially during the summer months, because they're not in school. So if they don't have childcare available, that might be tricky. But please advise your clients, encourage them, please do not bring your children, because you are not here to babysit them. You will not have a babysitter. Your assistants are not there to babysit the clients' children. So just make sure that you do emphasize that if they have children, to please make other arrangements and be flexible with them because of that. If necessary, maybe you meet them first on a one-to-one, like in person, and then later on do some interviews by phone, follow-ups by phone, and then bring them back in. Okay, but try to be flexible. And then at the end of it all, you do want to provide them with a copy of everything that you have filed for them. And I think most of the cases for Akin are English speaking, but if you do need to, and for those, Alan and Overy, it might be other languages, so make sure that if you are working with interpreters, you do reassure your clients about confidentiality, that the interpreter is covered by the confidentiality standard and provisions, and so it's okay to talk to them about that stuff. And then we have online resources. Look at this. Again, you're going to get your forms here. Check case status, processing times, things like that. Yes?
We have a team of 7. Do teams traditionally, all 7 people sit in a meeting with the client? That seems a little bit excessive.
That is excessive. That's a lot. Wow. We usually, wow. Yeah. Yeah, that's a little bit daunting for a client to come into, like a team of 7 people. So I would say maybe 2 or 3 of you meet with her. I mean, like maybe all 7 of you meet so she knows how many people are going to be working on her case, and then half of you I would suggest leave, and then like 2 or 3 of you stay and say, okay, everybody's going to be working on your case, but we're going to be here today to sign, and then you might be seeing some of us rotating into different meetings with you. Right? So just do it that way. Again, introduce the whole team, but I would not want the whole team to stay because it can get chaotic for the client and it could get chaotic for all of you. And you don't need 7 of you taking the same exact notes, but maybe 2 or 3 of you taking the notes together to see, oh, you know what, she said this, do you remember that? And oh, I missed that part, did you remember this? To kind of bounce off of each other, but I wouldn't have all 7 of you in the room every single time you meet with her. Any other questions? We're at the end of our training, so any questions on any of this? Is there going to be done an electronic copy of that manual? Yes, the manual is going to be electronic. Okay. Yeah, it's going to come to you electronically. Martha, is she here? Yeah, Martha's going to be sending it to the pro bono coordinators here, and then they're going to be sending it out to all the teams. Okay. Again, we're just putting on the finishing touches to it. Couple of things I just wanted to change up, so it will be coming to you shortly, hopefully within the next day or 2. Okay. Any other questions? If you do send me things, please send it to me in Word format if it's a Word document, so that I can easily track change and then send it back to you guys. It's easier for you, easier for me, better than me writing stuff and scanning and then you having to decipher everything I'm saying. So again, that kind of stuff. Any other questions? Nothing? Okay. If you do contact your mentor and they're out, they will have an out of office somebody to contact again. So you won't be left with us going on vacation for a week or whatever and nobody calling you back or talking to you. Somebody will, you can always reach one of us. All right, thank you so much. Okay, one last thing Martha wanted me to remind you. Please, evaluations, please fill out the volunteer information sheets. We just need this for our purposes to be able to, make the trainings better and or also track you down to make sure that we have all of your information too. What languages you speak, all that stuff.
What if we? Yes. I'm sorry. What if we haven't been assigned a case yet?
If you haven't been assigned a case, that's okay.
So we just hold on to this form and wait.
You could give it to Martha.
Okay, just unfinished.
Unfinished, it's fine. Are you in Akin?
Yeah.
Okay. So did you guys not get your cases yet?
No.
Some of us did.
Some of you did. Okay.
I actually don't have the information right now. I have to go down to my laptop.
Okay.
Here,
That's okay.
Here, I have it. We're on the same one.
Oh, right. Oh.
Thank you.
Okay.
Yeah, I don't have my direct dial either.
Oh, no.
All right.
I just use,
So,
it's
my
in the
understanding
email.
is everything that we're
I don't
doing
think
is
you emailed
immigration. So
before.
even though I got all these papers about this uncontested.
Oh, yeah.
Yeah.
We're not doing
No,
anything.
no, you're not doing any of that.
So
Just
do I
immigration.
check this? Do I not?
No. You're just doing check that. Yeah.
Yeah, I thought it was just like first initial last.
I'm the only one because there's an A Garcia, so mine is actually got her signature. I'm
do you
a
want
little
these?
special.
Martha wants them.
This is your
So much.
Yeah, thank you.
Thank you.